Good evening everyone. I am Anirudh Chaudhary, an assistant professor. I am a part of the Into Legal World team, and we would be discussing the inner intricacies of an online paper which has captured the attention of a lot of people in the recent times, especially in India. And that deals with constitutional law and human rights, mostly from an Indian perspective. Now, before we delve into Module 1, this module is supposed to give you a brief introduction as to how we would be planning out. This video plans to see as to what are the intricacies of this subject and why is this subject of pertinence and importance in this present world. Now, before we delve further into this subject, we first need to understand that as a student of law, everyone is required to have a very basic and a very innate understanding of the concept of law and constitution. When India became independent in 1947, we were faced with a big task. A task of a new nation, saddled with a lot of challenges. We had to follow the rule of law, and that rule of law could only be enunciated or protected by a supreme piece of law, which would have made it sure that it governed all other aspects of law in the country. Therefore, before we got independence, the Constituent Assembly was set up on 9th December 1946 to draft our own constitution. That constitution which would have given legitimacy to the Indian Republic, to the Indian democracy, the fledgling fields of the Indian vibrant legal and political system. All of us know this fact that the Indian Constitution came into effect on 26th January 1950 as a whole. After the Constitution came into force, it became the most supreme law of the land, from which all other laws derived the legitimacy. I will not be wrong in saying that Constitution is also known as the grand norm of the country, a very basic norm which every modern nation seeks to have. We might discuss as to what is its importance with human rights. How is it innately important to also human rights? Well, in this there are a lot of aspects. The first thing which we need to remember is the fact that the Constitution made prerogative was to rule the country under the realm of rule of law, and to also make it sure that the basic rights of the citizens were protected at all costs. These basic rights were termed as fundamental rights, which we had borrowed from the US Constitution. Presently there in Part 3 of the Constitution, from Articles 12 to 35, they are the most basic rights available to any individual, and I would be further discussing as to how certain rights are also available to foreigners. This is a very critical way through which the fundamental rights of people were protected, and the concept of human rights as a whole was also sought to be protected. Over a period of time, the Honorable Supreme Court and various high courts have sought to broaden the interpretation and the meaning of fundamental rights. For example, if I take about Article 21, the bare reading of Article 21 says that nobody shall be deprived of his or her life except according to the procedure laid down by law. Of course, it's a very rough interpretation. Over a period of time, the Honorable Supreme Court and a lot of other high courts, in a catena of cases, have made it sure that this meaning of right to life with liberty and personal dignity under Article 21 was broadened so as to inculcate a set of sub-rights like right to education, right to legal aid, right to health, right to clean and healthy environment, and of course all of them was supposed to be enforced by the state and was justiciable against the state. Apart from that, there have been a lot of other provisions which have spoke about how Constitution, Constitutionalism and human rights are interlinked with each other. They say a robust democracy can only function when there is a system of a set of rules and regulations which are dynamic in nature, which give a variable interpretation, which at the most of the times is for the benefit of the people and the society. This is the job of the Indian Constitution. Now, further when we dwell into the topic and when we dwell into the modules as presented by me in consonance with Into Legal World, you will find out that Constitution is not all about fundamental rights, but a host of other provisions, rules and legislations, and apart from that, a lot of other human rights provisions, which very subtly have meant that at all points of time, the main focus of the Constitution is the greater betterment of the greatest number of people. The aim of social justice interlinked with human rights, and of course, nowadays there is also a talk that perhaps no constitution in the world can be a static constitution. It has to be a dynamic constitution. In the 21st century, in the changing realms of law, constitution, human rights, humanitarian law, and more importantly, international humanitarian law, the importance of all these subjects have been more closely felt. In the next few weeks, we would be discussing, through the study of Constitution and human rights, the various aspects of the Indian Constitution, the various parts of the Indian Constitution. How do they function? How does the concept of fundamental rights, human rights, and a host of other rights subsist with each other? I know all of you are excited to go on with this journey. This is just the beginning. And last but not the least, as the poet Robert Frost had once said, the woods are lovely, dark and deep, and I have promises to keep, and miles to go before I sleep, and miles to go before I sleep. Thank you. Prospective students, in our next video, we would be discussing about Module 1 of this course. Thank you, and all of you have a great day.